call, and I call Jan Logie, 5 minutes.
Thank you, Mr. Speaker. Rise to take a short call on the Patents, Trans-Tasman, Patent Attorneys and Other Matters Amendment Bill. My colleague Gareth Hughes has given the major contribution on this, the first reading previously, and I commend people to watch that. My colleague Gareth has informed me that this is a critically important issue for New Zealand, and while most of us in New Zealand may not be all over patent law, I think most people do understand that if we are going to position ourselves strongly as a country, economically as well as socially, we would benefit from moving our economy more towards one based on innovation and low carbon, green tech, and more of a knowledge-based economy than the current low-wage economy centred around the depletion of our resources and forests. So patents are very relevant in that context. What this bill does is three specific things, and I'm not going to repeat what everyone else has been saying in too much detail, but what it does is that it creates a single patent application process and a single patent examination process covering both Australia and New Zealand. And this, while some people may listen to that, and I think on my first reading of that, I thought, oh, this is going to bring up issues in terms of sovereignty and the differences between Australia and New Zealand. But interestingly and encouragingly on closer reading, what it doesn't seem to do that. What it does is provides one portal for applicants to put in, to file their applications for Australia and New Zealand, because 95% of patent applications filed in New Zealand are also filed in Australia. So now you'll no longer need to file in both places. You can just file through one portal and it will go to both places. And that you'll just have to pay once rather than twice in two different countries. But it will be considered by an examiner in Australia according to their law and an examiner in New Zealand according to our law. So there's no change in terms of the status of our laws in that sense. It is just providing an easy pathway in and streamlining it and reducing costs for applicants. And when New Zealand has, I think, 4 times fewer patents being filed than the OECD average, I think it's a pretty clear indication that we need to be doing more to be able to encourage innovation in this country and ease the way and create the environment for people to start thinking about patents and about inventions and about how we could be setting up new projects in this country. So this bill also does is that it will amend the 2013 Act to explicitly exclude lack of unity of intervention as a ground for opposition in the pre-grant process. And it seems we've been told that this was a drafting oversight in the legislation. The questions have been raised by other speakers in the House tonight who were part of that, seeing that legislation through in 2013, that have said they personally will be interested in hearing submissions and examining that point more closely, because there was it was a very thorough process apparently. But drafting errors do happen, particularly when it's a comprehensive piece of legislation, as that was, dealing with a law that hadn't been changed in a very long time. I do note that some lawyers' response have been saying it's good to see this being fixed up. Some people have raised the question about why it's not being retrospectively amended, and while the Greens certainly don't usually support retrospective legislation, I do think the point they made, or the way I read it, was interesting in that it's quite possible some applications have been filed and not yet examined. So that's worth consideration. Thank you, Mr. Speaker.